All right, so looking at our predicted subjects in greater detail, which I suggest you do. The whole idea now is we want you to get anchor points in the various fields. We're obviously not teaching the entire subject, but we want you to get a foothold. In agency, what you should do is begin by defining the agency relationship. So let's back up. Your question is always going to be, can we hold a principal liable for the acts of an agent? Well, the first step would be to form the agency relationship. In an agency relationship, we have a principal and we have an agent, and the agent is operating on behalf of and under the control of the principal. So you have to look at, is he working on behalf of the principal, and is the agent working under the control of the principal? If you establish that, you establish an agency relationship. Next question, can we hold the principal to the contracts entered into by the agent? Answer, contracts entered into with authority bind the principal. So what we want to do is see, does the agent have authority, where authority is actual implied, actual express, apparent authority, and ratification. And I'm not going to go defining all those. I heard this, some of these are getting too long, so let's just get straight to the point. Next big issue, and this could be a crossover with torts. Can we hold the principal, or let's say employer, liable for the torts of the employee? And the answer is going to be torts committed within the course and scope of employment bind the principal. And so what we want to do is say, was the tort within the course and scope of employment? One issue, there's some issues that the bar likes to see discussed here, frolic and detour. Frolic is a major deviation and usually will cut the chain of events and let the principal off the hook. You should look at that. Independent contractor, we take a second look because the employer is not going to be liable for the torts of an independent contractor, generally. And is it independent contractor? Well, the main issue is going to be control. If the principal has control over the independent contractor, then really that's just independent contractor in name, and that's really an employee. But if there's no control, then that's an independent contractor. And there's a borrowed servant rule. Let's say you're working for someone and in a law practice, and the attorney next door comes over and says, yeah, I really need somebody to help me out. And your boss says, okay, go help him. So that's your borrowed servant. Who's going to be liable? The answer is the original boss, your boss, is going to be liable unless a whole new agency relationship was found, such as that now you are working under the control of and on behalf of the new employer. Finally, there's the issue of intentional tort. Generally, an employer is not going to be liable for the intentional torts of his or her employee. Exception, the act benefits the employer. All right, you need to know that. You need to wrap it up. You need to get it under your belt. But you know what? It's fairly limited. You don't have to know everything. So a couple of other things. Agency, partnership, an association of two or more people working in a business for profit. And the trouble with the partnership is there is joint and several liability for the torts of each other or all of the partners. It's unlimited and it's personal. They'll go into your personal bank account. There's no protection. So people will try to form another business entity, one that's protected, a statutory business entity such as an LLP, an LLC, and so on. And here is the rub. If you try to form an LLP, limited liability partnership, an LLC, limited liability company, if you try to limit your liability, you have to file with the state. If there is a defect, this is not like corporations when you're talking about these other business entities. If there's a defect, then the default is a general partnership. So whereas a couple of people might think they have protections of an LLC or an LLP, they don't unless they have perfected the business entity that they're trying to form. That's an important concept that you'll want to know. Otherwise, the partners are going to be jointly and severally liable for the acts of each other. All right, I hope this is helpful, and I know you're studying really hard at this point, and I'm basically with you in heart. I really am.
In the following webinar, Dr. Saccuzzo will talk through the issues we most frequently see tested in corporations. The dates you'll see on the brief summary behind him are dates those topics were tested in California on the essays.
All right, so basically, what are the big issues? On formation, it's piercing the corporate veil. Look, we list there for you all the times this piercing the corporate veil has been an issue. And you can see, given that this subject has been rarely tested in recent memory, look all the times that they've tested formation and piercing. You need to know the basic theories for piercing. And watch out for a promoter. The promoter is liable on the pre-incorporation contracts. On formation, to perfect the formation, you've got to file with the secretary. That's one of the things that frequently does not happen. Corporations gives you the option to discuss the doctrines of de facto and estoppel. You need to discuss both of those if you have a failed corporation. Even though these are no longer majority rule, somehow you still have to cover them. All right, so again, I talked about piercing. You've got to know the theories. When they test piercing the corporate veil, they usually give you more than one theory you can use. If you only see one theory, then you lose points. So I list the theories there for you: alter ego, fraud, inadequate capitalization. You got to keep all three in mind. And there's an issue on capitalization that was tested in Feb 2017. It's fairly rare, but you got to know this anyway. Under the modern majority, shares may be paid for with any tangible or intangible property or benefit to the corporation. Well, if you look at what they test, you'll see that fiduciary and director duties, probably one of the most frequently tested areas. And if they're testing fiduciary duties, you must discuss both due care and loyalty to succeed. Due care goes to your business decisions and reasonably prudent person managing their own business. And the breach of the duty of due care, or the potential breach, allows the director to bring forth the business judgment rule. And you have to discuss that. So due care and business judgment rule go together. Even though the modern standard is gross negligence, you still have to talk about it. Duty of loyalty, there has to be a personal gain. So in due care, you look for business decisions. In, they invested and they lost money. Okay, that could be a breach of the duty of due care. Breaching the duty of loyalty, they lost money and they gave it to their friends or to themselves. Director duties, I list personally managed. Go over those director duties. They've tested them frequently. And no, you got to know, the president has inherent authority to bind the corporation to contracts. No other officer has such inherent authority. It would have to be somehow expressed in the hypothetical. Continuing on the big issues to look for, shareholders, they do test it. I mean, the thing is, so the shareholder is not going to be liable for corporate debt. That's your overarching general rule. And then, of course, you have piercing the corporate veil as the exception. The shareholders have no right to a distribution. And another issue you need to know is derivative suit. How do you know? You need to talk about derivative suit. They'll tell you in the hypothetical that Polly, the plaintiff, brought a derivative lawsuit. Know how those work, know the definition, and know how to enforce the corporation's right in a derivative lawsuit. Now, they haven't tested in a while And to me, I'd be really worried about it. The common and federal securities laws. Now watch how you get a question that says discuss federal securities laws, or don't discuss federal securities laws. What are federal securities laws? 10b-5 and 16b. Okay, as to the common law, you've got some specific law on the sale of controlling interest and issues of fraud, non-disclosure, special facts doctrine. Look that up if you don't know what it is. Now, be sure you can do an analysis of 10b-5. Now, we've got the rule there: unlawful for any reason, by use of any means or instrumentality of interstate commerce, to employ a scheme to defraud in connection with the purchase or sale of securities. That's 10b-5, and basically we list the elements there for you. You need to find an instrumentality of interstate commerce. The phone is the usual one. You need to find some scheme to defraud. That could be breach of duties, getting a personal benefit, failing to disclose, failing to investigate. You have to find scienter, which they define in the statute, intent to deceive, and it could also be reckless purchase or sale of securities. That's the standing element. Now, when they talk about discuss federal securities laws, you've got to discuss 10b-5 and 16b. You need to really work through these or see past hypotheticals that have gone through how 16b short swing profits work. You need a corporate insider who buys or sells or buys within a 6-month period. That's it. It's a strict liability offense. There's going to be no defenses. If an insider buys and sells within a 6-month period, then it's going to get disgorged.